The Supreme Court is hearing arguments on Texas's new abortion law. The law bans most abortions after 6 weeks of pregnancy. The justices are taking up challenges in 2 cases over whether abortion providers or the Justice Department can start federal court challenges to the Texas law. The abortion procedure is not at issue in either of these cases, but they could help to reshape productive rights across the country. For more on this, I want to bring in Tang. He's a professor of law at the University of California, Davis. Professor Tang, welcome. Great to have you with us. So the high court split 5-4 in declining to block Texas's ban before it took effect in September. So can you explain to our viewers what issue is the court weighing here exactly, and why have they decided to hear this particular case?
Sure. So the justices are just deciding whether anybody could bring a lawsuit to challenge SB 8, Texas's law that bans abortions after 6 weeks and outsources enforcement of the law to private persons, private citizens who can get $10,000 in damages for any abortion that's performed. So the justices are just trying to decide, can either the abortion providers, an abortion clinic in Texas, Whole Woman's Health, or the Department of Justice under the Biden administration sue to block this law because it, at least on current precedent, clearly violates Roe versus Wade's rule that states can't ban abortions before 24 weeks.
So let me back up for a second. If they decide, hey, no, these aren't the right people to sue, who could sue? Like a Texas individual? Would that be the next step? I mean, they're saying the federal government can't sue. They're saying the abortion providers can't sue. So who would be able to sue?
So I think it's unlikely the court will make that decision. The oral arguments just wrapped up about 45 minutes ago. And if you were listening, the strong sense is that at least 6 justices are going to rule that the Texas abortion providers can sue to block the law, and possibly the Department of Justice as well. If they reach the other outcome for some reason, what they would say is that a Texas abortion provider has to violate the law, has to get sued to pay these $10,000 and more in damages, and then can, as a defense in that lawsuit, can argue that the law violates Roe versus Wade.
Okay. Would they also accept a case from an individual, let's say a Texas woman who says, you know, my rights were violated because I was not able to get an abortion in Texas? So far, individual women haven't sued because they're not actually punished by Texas's law. Texas's law puts the providers and nurses and other practitioners who aid the provider. They're the ones who face the $10,000 penalty, not the women themselves. So it's arguable, it's quite possible the court would say a pregnant person themselves doesn't have standing to sue. But the writing on the wall seems to be the court is going to protect its own power here and say the providers can sue or the Department of Justice can sue. All right. Well, that is some breaking news from Professor Tang here, because that would definitely set back this Texas law, correct?
It would set back the Texas law, but this is only, part of the big question about abortion and the future of abortion in America. Texas's law is an attempt to get rid of the right to abortion through the back door by outsourcing enforcement of this abortion ban to these private parties. But next month, actually exactly a month from now, December 1st, the Supreme Court's going to hear oral argument and consider overruling Roe versus Wade through the front door in a case that comes out of Mississippi.
Okay, so let's talk about how this case could impact then future abortion laws, as you were mentioning, because it isn't just about the Texas law. Obviously, that's why the whole country is watching it so closely. If let's say, the court hasn't ruled yet, let's say the court decides to let that Texas law stand, is that just one step down the road to eventually getting rid of Roe v. Wade?
I think it would be a big step if somehow the court allowed Texas's law to stand, because any other state that opposes abortion could enact the same law and basically ban procedures in the state. We've seen in Texas that clinics have virtually shut down. Pregnant persons have had to go out of state. Many are engaging in self-care or foregoing safe abortion care altogether. So other states could do the same thing. But I think the reason the Supreme Court isn't going to let that happen is because if Texas can get rid of the right to abortion, then California, New York could pass a law outsourcing private enforcement to get rid of the right to own a gun at home for self-defense, or the right of corporations to engage in campaign spending.
So interesting. Of course, the High Court is going to hear a challenge to Mississippi's abortion law next month. That one differs from the Texas law. What's at stake there?
Yeah, so Mississippi's law is one of a more traditional attempt by an anti-abortion state to curtail access to the procedure. Mississippi bans procedures after 15 weeks, except in cases where the mother's life is at stake or there's a severe fetal abnormality. And the state itself enforces it. It threatens to throw abortion providers who violate the law in jail, right? So that's the standard law. And Mississippi is asking the Supreme Court directly to overrule Roe versus Wade. The rule in Roe is states can't ban abortions before 24 weeks in pregnancy. That's a period known as viability, where the fetus can first survive outside the mother. That's Roe's rule. But Mississippi says, no, we ought to be able to ban abortions earlier, in particular at 15 weeks.
All right. Well, Professor Aaron Tang, thank you so much for joining us. We appreciate your insight.
Thanks for having me.